Dear students, Namaskar. Uh, Before coming to the new chapter, I would like to interact in relation to the previous discussion, which was related to Article 29 and 30. Last time we discussed that in the case of PA Inamdar, the Supreme Court had overruled the particular portion of uh, Islamic Education Academy that was related to the reservation in admission in educational institution, including private education institution, because the Supreme Court had uh, held that in Islamic case that there had to be some portion or quantum of reservation or shared of seats, especially for fixed by the state government um, for the benefit of socio-economic backward class or weaker section, etc. But this reservation, which was introduced or which was upheld or which was appointed by the Supreme Court in Islamic case, was totally denied by the Supreme Court in PA Inamdar, and the Supreme Court held that once they are not being financed, they are not being aided by the state government, so the state government cannot ask any kind of reservation, especially reservation in private unaided educational institutions. Now, the government, the decision was delivered in 2005. Now, the Dadan government had prepared itself for nullifying the effect of or the ratio of PA Inamdar case, and now the Supreme Court, Parliament introduced 93rd Constitutional Amendment and inserted clause 5 to Article 15 of the Constitution with effect from uh, 20th January 2006, and it's totally to nullify the effect of these uh, judgments, including your PMAPI or your PA Inanda, etc. And Article 15 clause 5 provides that nothing in this article or in Article 19 clause 1 clause G shall prevent the state from making special provisions by law for the um, advancement of any section of socially and educationally backward citizen, or for the scheduled caste and scheduled tribe, insofar as such special provision related to the educational institution, including private education institution, whether aided or unaided by the state, other than minority educational institution, means that as per the 93rd Constitutional Amendment, as per Article 15, clause 5, the the private education institutions, whether aided or unaided, they they were binding to give admissions to the OBCs, SC, STs in their private education institution, excluding minority education institution. Means that because the minority education institution has been excluded in the light of the importance of Article 30 clause 1. Now, the validity of 93rd Constitutional Amendment was challenged in one case. It was the Ashok Kumar Thakur versus Union of India, and was the case of 2008. And here, the Supreme Court, the Supreme Court negatived the argument which was raised by the petitioner that special provision for admission of SC of socially and educationally backward classes, SC/STs, in private education institution would make impossible to achieve the excellence in education, because the petitioner has raised that it will not be possible in case if we are going to admit the backward classes, socially and educationally backward classes in scheduled caste and scheduled tribe, not be possible to achieve the goal of excellence in higher education or in educational institutions, because they won't be able to cope up with general category. But the Supreme Court negatived Supreme Court declined that no, it will not affect or the goal of excellence. And the Supreme Court, it's the judge of the Supreme Court, Justice Bhandari, opined that it was not correct. It was not correct that 93rd Constitutional Amendment had abrogated Article 19 Clause 1 Clause G, and also violated the basic structure of the Constitution by inserting Clause 5 to Article 15 of the Constitution. A five-judge bench to, of Supreme Court, headed by Chief Justice, the then Chief Justice K.G. Balakrishnan, held that 93rd Constitutional Amendment, providing 27% reservation in admission of OBC candidates in higher educational institutions like your IITs and IIMs, are constitutional. However, the court left open the question of reservation to these categories in private educational institutions. The constitutional amendment provided that without touching the present strength of general categories candidates, the OBC give can be given special provision or reservation. However, held that the benefit could not be made or could not be extended or could not be made available to the creamy layers candidates. The creamy layer requirement uh, would not apply to the scheduled caste and scheduled tribe candidates who would be given reservation every year. So it was it was the all discussion, or it was the landmark case which had upheld the constitutionality and validity of constitutional 93rd Constitutional Amendment 2005 in contest of the reservation in admission in private education institutions. So now I'm going to discuss another important chapter which is related to the Article 368 of the Constitution. Article 368 talks about the amendment of the Constitution. Here, dear students, before coming to straightly to Article 368 or the provision of amendment, I would like to discuss little bit discussion on few provision of the Constitution which had been raised the question time to time, and even our student what is my past experience, that our students could not even make the distinction between few articles. So, because all those are so deeply interrelated to each other. But for the sake of little bit clarity, I would, before coming to the Article 368, I would like to discuss the few provisions of Constitution, especially uh, the provisions which are related to right to property. For your kind information, that after 1978, the area of property relation left only from constitutional rights. Means that after 1978, because you know that the 44th constitutional amendment, which uh, which repealed the fundamental rights fundamental rights to the property or fundamental rights of property under Article 31 and Article 19 clause 1 clause F of the Constitution. And now uh, that the Article 31A, 31B, 31C, and 300A, all these articles, although included fundamental rights, but hardly be character as a fundamental rights, because all these articles are related to the right to property as a constitutional rights. Now, in case if we talk about Article 31 clause 2, Article 31 clause 2 was related to the payment of compensation without any without any adjective like just or reasonable. And so laws uh, pertaining also come to the challenge, especially uh, under Article 14, 19, clause 1, clause F. And some laws were declared unconstitutional in the light of Article 32, clause 1. Article 32, sorry, Article 31, clause 2. Uh, especially in case if I like to refer the case of Kameshwar Singh versus state of Bihar. And central government, because of all these, uh, because of this judgment, the central government has got apprehended that the whole Jamidari abolition system or program would be endangered. So that's why, for the purpose of overcoming or to overcome the difficulty uh, created by this kind of pronouncements, like your Kameshwar Singh, that is delivered by the Patna High Court, the Dadan Parliament introduced the first constitutional amendment in 1951, and a new provision was added to Article 31A was added. And uh, what was the provision of 31A? That no fundamental rights under contained under contained Article 14, 19, and 31, but only constitutional rights for uh, providing compensation or means state could be acquired to be modified or without even compensation. However, any law made by the state legislature could not be protected unless received the assent of the president. President, and uh, and you know that for the purpose of the abolition of the Jamidari system, the fixation of ceiling on the agricultural land and the holding in the hands of the big Zamidar or one person for the development of panchayats or for effective village planning or management. And here I would like to mention that there was the question of compensation also, whether the compensation should be the adequate compensation or inadequate compensation. So the uh, uh, the one case was filed before the Supreme Court on the name of Bela Banerjee versus State of West Bengal, in which the question of inadequacy of the compensation was raised, and the petitioner argued that the adequacy of compensation is justiciable. So uh, it justiciable, and the Supreme Court held that the question of adequacy of the compensation is justified, and that's why it is justiciable, and the amount of the compensation has to be at least equivalent to the livelihood deprived by the petitioner, and that's why the Supreme Court has made it justiciable. Means the amount of compensation was made justiciable or unforeseeable. Now the Parliament introduced another uh, important constitutional amendment. It was the fourth constitutional amendment, and fourth constitutional amendment now had extended the scope of Article 31A, and now by adding few categories for the purpose of deprivation of the properties, especially agriculture land, industrial land, mining land, and all those lands, all those law which was related to acquire the agricultural land, industrial land, or mining land, uh, all those become immunized for the purpose of, or in the light of Article 49 to 19 and Article 31 of the Constitution. And now Article 31A, Clause 1. Article 31A, Clause 1, enacted by 4th Constitutional Amendment, 1955. 1955, the 31A, we can say, the 31 was to be operated, was remained in operation until 1978, means before the 44th Constitutional Amendment Act, which declared the right to property is not a fundamental right, it is a constitutional right. And as all of you know, that Article 31 was repealed by 44th Constitutional Amendment, and therefore reference to Article 31. In Article 31A and Clause 1 was dropped, but purpose of uh, pre 19 pre 1979 laws. Article 31A Clause 1 uh, should be read as containing such as reference of Article 31A Clause 1 says that notwithstanding in Article 13 following said no laws shall deem to be void on the ground that is inconsistent with the fundamental rights under Article 14, 19, 14 and 19. And all those laws which are related to the acquisition by the state, taking over the management of property, the statutes for limited period, limited in public interest, amalgamation of two corporation, in two corporation in public interest, and extinguishment of any fundamental rights, or extinguishment of any right, even the managing directors, secretary, managers, including shareholders of that industries, or industries, or corporation, etc. Now, the extinguishment of any rights in mineral or mineral oils, by the virtue of agreement, lease, license, etc. So Article 31A clause 1, in which is the acquisition of state, acquisition of the estate by the state, or acquisition by state of estate, or any right uh, related to the transfer of ownership to the states. Article 31A clause 1 also envisages the extinguishment, extinguishment of or complete termination of the above rights which are related to the transfer of ownership to the state. And now the question was one question was there, okay, what do you mean by estate? That the state means, because so far there was no uniform meaning throughout the country, no uniform meaning of the state throughout the country, and its meaning varies from uh, area to area, place to place, and hence one definition of state could not have met with the so far given situation or condition. So that's why the Article 31 clause 2 clause A meaning was given to the state by a local laws relating to the land tenure. Means that even now the definition of state was confined to the local laws which were related to the land tenures. For example, the state related to the Jagir, Inam, Muafi, etc. And in case if we talk about the state related to the Inam, it was granted in avenge of the tendered services. For example, the services tendered to the Britishers, and the Britishers had allotted the estate or land uh, like a Inam, and all those landholders uh, were holding the land and they were cultivating the land. But you know that prior to 17th Constitutional Amendment Act, it was the land tenure, or it was the one term, Rayotori, land was not protected by the uh, Article 31 clause A, clause 2, clause A of the Constitution, and that's why the 17th Constitutional Amendment was introduced for the purpose of to overcome this difficulty, uh, and now added a new clause to Article 31A, clause 2, clause A, which brings the Rayatari settlement within the term of state. And now Article uh, 31 clause A, clause 2, clause A, and even uh, clause 3. Any land, included agriculture, including wasteland, including vacant land, including forest, pasture, or kind of ancillary purposes, etc. So all these uh, categories, all these lands were supposed to be acquired, and all those were laws which were related to the acquisition of these lands were in confiscatory in nature and discriminatory in nature, and even the compensation was very little, and we can say it was a very compensation was illusory on the name of compensation, and that's why the scope of Article 31 clause A, clause 31 clause 1 clause A, uh, land inam without proving compensation. Now all these lands are going to be acquired even without compensation, and transferring the agriculture land from the landlord to the tenants, and the law fixing the ceiling on agricultural land to annul the lease with retrospective effect. annul the leave with retrospective effect by the district collector. And it's the Bihar Land Reforms Act. Bihar Land Reforms Act, which which was added to the ninth schedule, uh, empowered the collector to annul the anticipatory transfer of land for defeating the Bihar Land Reforms Act of 1950. So, because a law abolishing by then abolishing big landed estates, uh, for example, it was the Sholapur case, etc. So, 31A clause 1 clause B seeks to protect state against the claim for compensation, and no challenge to these laws under Article 14 and 19, uh, in case if it was to be acquired for the limited period, limited period. And here these provision protects the change and introduction the company laws also to eliminate the managerial agencies system, provide for compulsory amalgamation of two or more company in the national interest. Now another, because uh, there is a confusion between Article 31A and Article 31B. Now the Article 31B, which talks about the validation of certain laws. Article 31B, along with ninth schedule, added to the Constitution by uh, first Constitutional Amendment Act of 1951. The provision immunizes the various species of legislation included included or added in ninth schedule on the ground that it is inconsistent with the fundamental rights. Because here, all of you know that the Article 13 clause 2, which says that states shall not make the law which becomes inconsistent with the provision of fundamental rights, and in case if it is inconsistent with the provision of fundamental rights, that will be declared null and void to the extent of its inconsistency. So that's why for the purpose of overcoming this difficulty, the because in Kameshwar Singh case, it was raised that it is going to become inconsistent. The purpose of acquisition of surplus land was become the tool for violation of fundamental rights in the light of Article 13 clause 2. So not only this, in case if we talk about Article 31B, which provides for the which provides for ninth schedule also, that Article 31B is a retrospective in nature. How it is retrospective in nature? When a statutes declared unconstitutional by the judicial pronouncements by the court, and in case if it is going to be later on it is going to be included or added to the ninth schedule, then it is to be considered as having been that to be a void, or even to have become void on the ground of its inconsistency with fundamental rights. In short, we can say the judicial decision is nullified when when the statute or legislation or act or rules included in the ninth schedule. So since 1951, ninth schedule has been expanded constantly. Uh, so from the constantly so much that today, or we can say that now today we are having more than 284 acts which had been added to the ninth schedule, and all are included in ninth schedule from the context of Article 31B. So it is put under the heading of right to property from the context of Article 31B. What does it say? It is put under the heading of right to property immediately after Article 31 and Article 31A, and it's contained in Article opening words of uh, opening words of Article 31B say that without prejudice to generality of the provision contained in Article 31A. So it could logically be assumed that Article 31B was meant to protect the legislation dealing with the property rights and not any other type of legislation. But in practice, uh, Article 31B has been used to invoke protection of many laws not concerned with fundamental rights at all. Not concerned with your property rights at all. And Article 31B is thus being used beyond the socio-economic purposes, which was its only justification. What does it mean? Is that uh, uh, primarily when the provision of 31B or Knight's rule was contained in our constitution by the first constitutional amendment, it was aimed to give agrarian reforms in the country. But later on, in the pretense of ninth schedule, the other than laws, the other laws which were not related to the agrarian reform, even they were added to the ninth schedule, and with the result, what happened that today we are having more than 284 laws added to the ninth schedule. Now, this problem uh, of ninth schedule has been raised time to time, and now we'll be discussing uh, these two articles with the reference of amendment of constitution and various case laws, uh, decided by our Supreme Court. So now, uh, coming to Article 368, which talks about the provision of fundamental rights. Now, question arises. Article 368 talks about the provision of amendment of the Constitution. Now, question arises: what were the necessity of inserting the amending provision in our Constitution or in any Constitution? We can say, because you know that as all of you know that times are not steady. Time changes, so life of the nation also changes with the changing scenario of the society, or it's the uh, 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 it's the life of the nation is not static, but that has to become a dynamic, uh, living, and organic one. And you know that the political, social, and economic conditions of any country always having its impact on the growth of the nation, on the growth of the society, or on the growth of the uh, lives of citizens also. So that's why for the purpose of overcoming the difficulties which may encounter in future in the working of the constitution, because the constitution could not be proved as a static one. It could be remained a live one, dynamic one. So that's why it was the necessity to have the provision of to have the amending provision in our constitution, and for the purpose of molding the law according to the emerging issues and challenges of the society, according to the emerging requirements of the society, because the society is always kept on changing and kept on changing, and the scenario of the society is also kept on changing. So, if no provision was made for amendment, the people would have to resort the extra constitutional methods like a revolution to change the constitution. So that's why the framers, have desired to uh, have the chapter of amendment in any constitution for making a dynamic and live constitution. Generally, generally a federal constitution is rigid in character, as a procedure of amendments uh, is unduly complicated. For example, procedure of amendment in American Constitution is very difficult. So, is that case with Australia? The same case it is the Australia, Canada, and Switzerland also. So, it is common criticism of the federal constitution that is too conservative and too difficult to alter it. And the framers of the Indian constitutions were keen to avoid excessive rigidity. As all of you know, that we have got adopted the federal constitution, and in the light of the federal constitution, uh, which is having its nature a rigid constitution, so framers of the constitution were keen to avoid the excessive rigidity, and they were anxious to have a such document which could grow with the growth of the nation, or demands, uh, growing demands of the society, growing wants, desires, expectations, wants, or will of the society, and adapt itself to the changing need and circumstances of the growing people. So the nature of the amending process envisaged by the framer of our constitution can best be understood by referring of the words of late Pandit Jawaharlal Nehru, or Prime Minister Pandit Jawaharlal Nehru, what he quoted about the nature of the about the procedure of amendment, why there should be a procedure of amendment. He quoted in Constituent Assembly, while in debate in Constituent Assembly, that while we want this constitution on one hand, while we want to this constitution so solid and permanent as we can make it, there is no permanence in the constitution. There should be certain flexibility. If you make anything permanent, you stop the nature, you stop the nation growth of living, vital, organic people. So in any, even we could not make this constitution so rigid and permanent, it cannot be adopted to the changing conditions and circumstances. So in case if we make it permanent and solid, then it will not be adopted the changing condition and circumstances of the society. So, but the framers were also aware the fact that if the constitution was so flexible, it would be playing off the whims and caprices of the ruling party. So therefore, they were anxious. They were anxious to avoid flexibility of extreme type. So hence, they adopted a middle course. It is neither too rigid to admit unnecessary amendments nor flexible for undesirable changes. So, uh, in one case, it's the landmark case, all of you know, that the Supreme Court in Keshwanand Bharati case had quoted the words of Wills in his book on the constitutional law of US. He says that if no provision for amendment were provided, this would be constant danger of revolution. If the method of amendment were too easy, there would be a danger of too hasty action all the times. In either case, there would be a danger of overthrow of our political institution. So, therefore, purpose providing for constitutional amendment is to make it possible gradually, gradually to change the constitution in an orderly fashion, as the change in social condition make it necessary to change the fundamental law to correspond with social change. And Dr. Ambedkar also in Constituent Assembly quoted that one quoted his observation and made one quotation that one can therefore safely say that Indian Federation will not suffer from faults of rigidity of legalism. Its distinguished feature is that it is a flexible federation. So, uh, what does it mean? That our constitution has adopted the middle course or middle path for the purpose of amendment of constitution under Article 368. Now, regarding the procedure or method for amendment of the constitution, we can talk or we can divide the methods or procedure into two categories. One is the formal amendment of the constitution, another is the informal methods of amendment of the constitution, or we can say one is the formal procedure, another is the informal procedure. Now, first I would like to go through the informal procedure or informal method. Informal method can be divided into two categories. One is the judicial interpretation, and another is the convention and constitutional usage. First, what do you mean by judicial interpretation? In this procedure means that judicial interpretation or judicial interpretation procedure, the constitution text does not change, but its interpretation undergoes change. So the words in constitution having one meaning in one context, but may be given somewhat different meaning in another context. While the language of the constitution does not change, the changing circumstances of a progressive society for which it was designed yield a new and fuller import of its meaning. Means that if the judicial interpretation which is going to modify, which is going to change the different meaning in different condition and circumstances of the society, and because you know that and it is not alone with our constitution or other constitution, even judicial interpretation is a process of slow and gradual uh, metamorphosis of constitutions principles, and somewhat it is invisible, for the change has to be deciphered by an analysis of a body of judicial precedents. So, in this process, the court play a dominant role because it is their function to interpret the constitution. So, if the courts, you know, sometimes because in case if the courts feels that the particular provision has become obsolete, has become defunct, then courts comes out for the rescue of the society or giving it a new meaning by interpreting the provision in the light of the emerging new condition and circumstances of the society. For example, though the uh, though the process of judicial interpretation goes on in every constitution to a greater or a lesser extent, means that it depends upon the constitution whether it is the constitution is a rigid one or it is a rigid or flexible one. So yet it assumes a crucial importance in a country in which a formal method of constitutional amendment is very tardy or rigid and difficult. The language used in the constitution is journal or etc. So, for example, because you know that it depends on the language also whether it is very journal or specific. For example, in case if we talk about the U.S. Constitution, where it the U.S. Supreme Court has from time to time given a new meaning that that all of you know that the U.S. Constitution is a rigid constitution and has been written in very general language. For example, it's the U.S. Supreme Court which has from time to time given a new meaning to the phrases and words in Constitution so as to make the so as to make the 18th century. For example, you can say share that it's the in 18th century the laissez-faire era expanding and highly industrialized civilization of 20th century without many formal amendments being effectuated in this constitution or in this contest. So it's the U.S. Constitution which was giving the new interpretation and new meanings to the provision of the U.S. Constitution time to time. So another example, the U.S. Constitution being skeletal and brief and couched in general language offers a vast scope for judicial interpretation or judicial creativity. For example, the first constitutional amendment of U.S. Constitution uh, guarantees to freedom of speech. In very broad terms, this constitutional amendment says that Congress shall make no law abridging the freedom of speech or freedom of press. So here the provision lays down no limits or restrictions on fundamental rights to freedom of speech, but there can be no unlimited rights. Therefore, if the U.S. Supreme Court has taken upon itself to spell out the restrictions on freedom of speech, means that even the the provision talks about the uh, absolute freedom of speech, but practically it is not the absolute freedom of speech because time to time it the U.S. Supreme Court which has been spelled out, which has been interpreted the freedom of speech in the given condition and circumstances of the U.S. society. Another example, to a limited extent, in Canada, Australia also, judiciary has adopted the constitution to the changing circumstances. For example, even in India also, although due to constitution being very detailed document and its language being rather specific and not general, but opportunities available to mold the constitution by the judicial interpretative process are somewhat limited, but somewhat limited. Yet there have been several outstanding judicial decisions which have had a deep impact on constitutional development especially post Menka Gandhi decision. The interpretative process has entered a dynamic phase because of the judicial uh, uh, creativity. For example, post Menka Gandhi, uh, we have got discussed under Article 21 of the Constitution, Francis Corley, M.H. Horscott case, Rudal Shah case, Prem Katara case, etc. So, lot of case, has been give a new interpretation to Article 21 of the Constitution. And recently, we can say the decision of Sabrimala, Dalsa, decision of Dalsa case ruled by the Supreme Court, decision of Joseph Triple Talak, and the decision of Adhar case that is filed by Justice Puttuswamy. So you know that it's the Supreme Court which had given a new interpretation, creative interpretation, for the purpose of keeping the law, for the purpose of keeping the provision, a live provision, a dynamic provision in the prevailing condition and circumstances of the society. Then the next informal process of process of amendment that relates to the convention and constitutional usage. The convention and usage, though operating without framework, without operating within the framework of the provision of the constitution, nevertheless do modify their content and effect. One way to distinguish between rules and convention may be to say that while rules are made, conventions are not made. Conventions evolve out practices followed over a period of time. Conventions operate in several ways. For example, convention may nullify a constitutional provision in practice without formally abolishing it. This is to be found, in fact, that in some countries, the legal power of head of the state to veto a bill passed by a legislature is never exercised by him except on the advice of Council of Minister. Means that although he has been empowered to veto the bill, but he never exercised it. It is a convention. He never exercised it except in the circumstances as and when he was advised by the Council of Ministers, then he could exercise it. Then we could cite the various conventions and constitutional uses, especially in the parliamentary form of government. And for example, as we discussed in our previous semester, last semester, the power and position of the president in parliamentary form of government. And all of you know that our the in case if we talk about the power and position of president of India, then he is the constitutional head of the state. He is the formal head of the state. He is not the real head of the state. Why? Because of the parliamentary form of India. Because always he always exercises powers, either its executive powers, on the advice of the council of, or through the aid and advice of the council of ministers. And on the same we can share the position of governor, that he also exercises powers of the aid and advice of the council of ministers. And all this would happen because of the reasons or because of the positions in England, and it was the position or it's the position of England in British crown. So uh, even as and when you know that lot of provisions talks about the assent of president. assent of president means that it is not the personal assent of the president, it is the assent through the advice of Council of Ministers or and the advice of Council of Minister. And nowadays, even under the stress of planning, new conventions have got rise up. For example, Planning Commission. Planning Commission, an extra constitutional non-statutory body, has come to have a good deal of control over the center-state relations. National Development Council is another example of extra constitutional body. This uh, and the power and function which are regulated not by the law but by the convention. Convention characterized as non-legal rules. Non-legal rules. Why non-legal rules? Because why non-legal rules? Because the courts do not apply them, and rules because the courts are binding and they are observed in the practice of the courts. Uh, in this connection, it needs to be pointed out that there are the cases. Sorry. In this connection, it needs to be pointed out that there are the cases where the courts have recognized convention, thus blurring the distinction to some extent between legal and non-legal rules. And some Supreme Court judges have even gone to extent of denying that there is a distinction or there is any distinction between constitutional law and established convention. So, for example, it's Justice Kuldeep Singh who has observed in one landmark decision on landmark judgment. It was the and all of you aware about that judgment, which has been related to the appointment and transfer of the judges. It was the case of 1994. It was the case of Supreme Court Advocate on Records Association versus Union of India. In that case, it was Justice Kuldeep Singh who observed that we are of the view that there is no distinction between the constitutional law and established constitutional convention. Both are binding in the field of their operation. And once it is uh, established to the satisfaction of the courts that a particular convention exists and is operating, then the convention becomes a part of the constitutional law of the land and can be enforced in like a manner. So we can share that it is the another method which can be which is being applied by the courts silently, invisibly, that the provisions of the constitution are going to be amended silently and invisibly, although all those are to be interpreted by the courts in the different circumstances and conditions of the society. For example, all of you know that in case if we talk about the provision of one important provision of constitution, that is Article 141, which which talks about that the decision of the Supreme Courts are binding to the all courts of the land. So here, uh, uh, as I cited, the article example of Article 21A, that although the Article 21, sorry, 21 was not amended by the Parliament in its content and meaning, but with the various interpretation of the courts, which has changed the contents and meaning of the important Article 21 of the Constitution. So uh, now I'm coming to the formal procedure which is to be covered under Article 368 of the Constitution. And as we discussed that our framers have got adopted a middle course for the purpose of amendment. Means that neither we adopted the rigid procedure nor we adopted the flexible procedure. We had adopted both according to the provision of the constitution, according to the situation of the situation and condition of the society. So for the purpose of constitutional amendment, for this purpose constitutional amendment of various provisions are divided into the three categories of procedures. One category is to be termed as the amendment by simple majority. And under this category, we can say that, for example, Article 2, Article 3, Article 4, Article 5, Article 169, Article uh, 9, etc. So, another procedure is the special majority, amendment by special majority procedure. Means that as and when we have a two-third majority total membership of each house, uh, both present and voting, each house of the parliament, and another is the special majority and ratification by the states, not less than half of the state legislature. So, where states are given importance or important voice in amendment under the constitution, we can cite the examples of your election of president, article 54, 55, executive powers of union and states, article 73 and article 162, article dealing with judiciary, article 124 to 147, article 240 to 231, distribution of legislative powers between union and states, article 245 to article 255, article 279A GST, and in case if there is a question of amendment of itself, article 368 of the constitution. Now the one question has been remained in controversy since the commencement of the constitution, since the enforcement of the constitution, which was enforced in 1950. So, as all of you know, that the present constitution was adopted on 26th November 1949 and was enforced on 26th January 1950, and with a view to fulfill a dream of dispensation of socio-economic justice assured in our preamble of constitution, the various states government had tried to introduce a new legislation for the purpose of abolition of zamindari system, and it was in state of Bihar. One act was introduced, the Bihar Land Reforms Act of 1950, which was enacted for the purpose of abolition of zamindari pratha and for the purpose of acquiring the surplus land of big zamindar. But it was challenged in Patna High Court on the name of Kameshwar Singh was the state of Bihar, and it challenged the Bihar Land Reforms Act, which was meant for acquiring the surplus lands. Here in Patna High Court, the petitioner argued that such laws are violation of fundamental rights under Article 14, 19, Clause 1, Clause F, and Article 31 of the Constitution. And government argued before the Patna High Court in the light of Article 37 of the Constitution and dispensation of socio-economic justice uh, for the uh, upliftment of the figure section and for the development of the nation. But the Patna High Court held that the fundamental rights are being justiciable and directive principles are non-justiciable, and that's why the Patna High Court declared the Bihar Land Reforms Act as unconstitutional and bad in the light of Article 14 of the Constitution because it was not because as we discussed that it was not providing uh, adequate compensation and the compensation was discriminatory. That's why the Patna High Court held that it is unconstitutional and bad in the light of Article 14 of the Constitution. While other high courts, like High Courts of Allahabad and High Courts of Nagpur, had held that similar laws were valid. Before the uh, Supreme Court gave its verdict on the validity or invalidity of the type of this type of legislation, the central government under Nehru became restive at the delay being caused by litigation in furthering the programs of agrarian land reforms. And though, though of short, circuiting the judicial process, Nehru was an ardent supporter of agrarian reforms, which he regarded as a process of social reforms and social engineering. So, as a result of these judicial decisions, the central government had got apprehended that the whole Jamidari system program would be endangered. To overcome this difficulty, the Parliament had given the first Constitutional Amendment Act 1951 and new provisions were added, and that is your Article 31A and 31B, along with 9 schedule to the Constitution, as we have discussed in detail regarding Article 31A. 31A laid down that no law providing for acquisition by the state of any estate or any rights therein or for extinguishing or modifying any such rights would be void on the ground of inconsistency with any of the fundamental rights under Article 14 and 19 and 31 of the Constitution. And 31B, if any right, if any acts or regulation added to the ninth schedule that will become immunized from an attack on the ground of violation of fundamental rights. Now, the government had uh, overcome the difficulties created by the pronouncements of pronouncements of the courts, like your the decision of Patna High Courts. Now, the the question was, as and when the Parliament had introduced the first constitutional amendment and which made the provision for Article 31A and 31B. Now, and which was uh, meant for uh, meant for not challenging the fundamental rights on their violation, even if they were violated, in case if they were uh, added to the ninth schedule, and the ninth schedule had taken its birth because of the uh, first constitutional amendments. Now, one question was raised before the Supreme Court, and one question was uh, felt by the society, whether constitutional amendment could take away the fundamental rights or abridge the fundamental rights in the light of Article 13 clause 2, which says that state shall not make a law which becomes inconsistent with the provision of fundamental rights. So this uh, important constitutional act or first constitutional act was challenged in the case of Sankri Prasad versus uh, Union of India in 1951, and it was the first case first case on the amendability of constitution, and first constitutional amendment act 1951, curtailing the right of property guaranteed by article 31, and it was challenged. The argument against the validity of first constitutional amendment, that the article 13 clause 2 prohibits the enactment of law violating the fundamental rights. The word law, the word law in Article 13 would include any law, even a law, because of constitutional amendment, and therefore the validity of such law would be judged and scrutinized with the reference to the fundamental rights, which is not which it not infringe. So here it was conflict between the Article 13 clause 2 and Article 368 of the Constitution. Here the Supreme Court had adopted the literal interpretation of the Constitution, and Supreme Court upheld the validity of first constitutional amendment. And the court rejected the and contention and limited the scope of Article 13 of the Constitution by ruling that the word law in Article 13 would not include within its ambit or within its compass constitutional amendments laws under Article 368 of the Constitution. So the Supreme Court stated that on this point, that we are of the opinion that it is that is the context of Article 13. A law must be taken to mean rules and regulations made in exercise of ordinary legislative powers, and not a constitutional amendment made in exercise of constituent power, with the result that Article 13 clause 2 does not affect constitutional amendment made under Article 368 of the Constitution. So the Supreme Court held that the terms of Article 368 are perfectly general and empower Parliament to amend Constitution without any exception. The fundamental rights are not excluded or immunized from the process of constitutional amendment under Article 368 of the Constitution. So these rights would not be invaded by legislative organs like legislature and executive by means of their laws, or by means of exercising of their uh, legislative powers and rules made in exercise of legislative power. But they could certainly be curtailed, abridged, even nullified by alteration in the constitution by constitutional amendment. The court, the court insisted that there is a clear demarcation between ordinary law, which is made in exercise of uh, legislative powers, and the constitutional law, which is made in the exercise of constituent power. Both Article 13 and 368 are widely phrased and conflicted in the operation of each other. So, to avoid the conflict, the the principle of harmonious construction should be applied. Accordingly, accordingly, one of these articles ought to be read as being controlled and qualified by other. So, in the context of Article 13, it must be read subject to Article 368. Means that Article 13 cannot control Article 368. Rather, Article 13 ought to be read subject to Article 368. So, therefore, the word law in Article 13 must be taken to refer the rules and regulations made in the exercise of ordinary power, legislative power of legislatures or legislature or executive, not to constitutional amendment made under constituent power under Article 368. With the result, Article 13 Clause 2 does not affect constitutional constitutional amendment under Article 368. So this, so thus we can say the court disagreed with the view that fundamental rights are inviolable, or means that never to be attacked or dishonored. Means that they disagreed that they cannot be attacked or cannot be cannot be attacked or cannot be dishonored. They can be uh, they can be attacked in the given circumstances by the given circumstances because of the constitutional amendment. And beyond the, they also rejected the contention that fundamental rights are the beyond the reach of the uh, beyond the reach of the process of constitutional amendment. So the Supreme Court thus ruled that Article 13 Clause 2 to a legislative law to a legislative law that is related to the ordinary law made by the legislature, not to a constitutional law uh, that is law made by the constitutional amendment. So, thus the Supreme Court held that Parliament could, by uh, following procedure laid down under Article 368, amend any fundamental rights enumerated under Part 3rd of the Constitution. And as I got mentioned earlier, also as I discussed Article 31A, that I discussed one case, Bela Banerjee versus State of West Bengal, and because of the consequences of the Supreme Court. In that case, the Supreme Court held that the question of adequacy of compensation is justiciable. Means the compensation, the question of would be justiciable, and that had created difficulty before the Daden Parliament, and that's why the Parliament introduced another constitutional amendment. It was the amendment of 1954, fourth constitutional amendment, 1955, for the purpose of nullifying the effect of the decision of Bela Banerjee. And now again, uh, again the fourth constitutional amendment made the issue of adequacy of compensation non-justiciable. Now, another important case which relates to the amendment of the constitution is the case of Sajan Singh versus state of Rajasthan. We can say that for the because the decision of Sankari Prasad was uh, decided in 1951, in which all of you know uh, that first constitutional amendment was challenged. So the decision of Sankari Prasad, we can say, had been remained in force for the next 13 years. It was the country which was following the Sankari Prasad, and the question of amendability of fundamental rights remained remained eclipsed, remained dormant for 13 years. But after 13 years, in 1964, the same question was raised in Sajan Singh when the validity of 17th Constitutional Amendment 1964 was called in question, and the Constitutional Amendment again adversely affected the property rights, and by this constitutional amendment a number of statutes affecting the property rights were added to the ninth schedule. And here what we came to know that around 44 uh, acts and rules or statutes were added to the ninth schedule by the 17th constitutional amendment 1964, and and thus all those immunized from court scrutiny. And in this case, two important questions were raised before the court, or were raised to decide by the court. First question, whether constitutional amendment insofar as it purported to take away or abridge fundamental rights was within the provision of Article 13 clause 2, means whether constitutional amendment so far which was appeared to take away the fundamental rights or abridge the fundamental rights, can now was within the provision of Article 13 clause 2. And second question, whether Article 31A or Article 31B, as I have discussed, that both these uh, uh, articles were amended by the 17th Constitutional Amendment. The amended Article 31A, Clause 2, Clause A, Clause 1, which talked about the Rayotari land, as I could mention, Rayotari land was not protected before the 17th Constitutional Amendment, but by the 17th Constitutional Amendment, Rayotari land was also included under Article 31A, Clause 2, Clause A, Clause 1, and which was meant for the purpose of acquisition. So, and it was protected under Article 31A, or newly amended Article 31A by 17th Constitutional Amendment, and by 17th Constitutional Amendment, uh, uh, Article 31B was also amended, and I would mention that around 44 acts of different states were added to the ninth schedule. uh, Added to the ninth schedule, and it was asked if whether Article 31A and 31B sought to make a change to Article 132, 136, and Article 226 or any of the list in 7th schedule of Constitution, so that the conditions prescribed in proviso to Article 368 had to be satisfied. One of the argument uh, was that 17th Constitutional Amendment reduced the area of judicial review, as under ninth schedule many statutes has been immunized from attack before the court. So it had affected Article 226 and therefore could be made only by the following the procedure prescribed under Article 368 for amending the entrance provision, because that was required to be amended by the ratification more than of the half of the states. So that is the ratification or concurrence. At least half of the states are to have been secured for the amendment to be validity effectuated. Such an argument had also been raised in the Sankri Prasad by the but without success. The Supreme Court again rejected the argument by majority 3 to 2. The majority ruled that the pith and substance of the constitutional amendment was only to amend the fundamental rights so as to help the state legislature in enforcing the policies of agrarian reforms, and it is if it is affected Article 226 in an significant manner, that was only incident. So it was an indirect effect of 17th Constitutional Amendment, and it did not amount to an amendment of Article 226. Means that although there was an incidental encroachment to Article 226, but it was indirect, and there was no question of the amendment of Article 226. So the Impugned Act did not change Article 226 in any way. So the conclusion of Supreme Court in Sankari as regard the relation between Article 13 and 368 was reiterated by the majority, and it felt no hesitation in holding that the constituent power on Parliament under Article 368 could be exercised over each and every provision of Constitution, and the majority refused to accept the argument that fundamental rights are or fundamental rights were eternal, inviolate, and beyond the reach of Article 368. And Supreme Court again draw the distinction between ordinary law and constitutional law made in the exercise of constituent power, and held that only the former and not the later fell under Article 13 of the Constitution. However, the majority, however, the majority, uh, however, the minority, sorry, however, the minority consisting Justice Hidayatullah and Justice Mudholkar, in separate opinion or in their separate judgment, expressed some reservations on the question whether Article 13 would not control Article 368. It was Justice Hidayatullah it was Justice Hidayatullah, who observed, I require stronger reasons than those given in the Sankri Prasad case to make me accept the view that fundamental rights were not really fundamental but were intended to be within the powers of amendment in common with the other parts of constitution and without concurrence of states because the constitution gives so many assurance in part third and that it would be difficult to think that they were play think of special majority of ruling party. On the other hand, it was Justice Mudholkar felt reluctant to express a definite opinion to whether the word law under Article 13 clause 2 of Constitution excludes an act of Parliament amending the Constitution and also whether is competent to Parliament to make any amendment to all part of third of the Constitution. But Justice Mudholkar argument was set in a much broader frame. His basic argument was that every constitution had certain fundamental features which could not be changed. So, so you know that the although the recent view given by the two eminent judges, intelligent judges, and which will play a vital role. Their recent view will play a vital role in coming two judgments. It's the that as you will see uh, in next case, it's the Golagnath case, which was based on the judgment, which was based on the opinion of Justice Hidayatullah argument that fundamental rights are non amendable or non amendability of fundamental rights. And the opinion which was uh, opined by Justice Mudholkar, it was based, or the we can say the Keswanand Bharti case was based on view, Mudholkar views of basic feature because it was the Mudholkar uh, who had argued that every constitution has certain fundamental feature or basic feature which could not be destroyed, which could not be changed. And thank you, and then we will see in the coming lecture, in the coming these two important cases, Golaknath and Keshwand Bharti, that how much the opinion of these two judges played a role in making the decision. Thank you. Before paying my thanks, I again would like to uh, make a request that in case if you feel any difficulty or doubts, then kindly you may ask to Mr. Man. The students from section A, they may ask to Mr. Man. Students from section G, they may ask to Mr. Agarwal, Abhishek Agarwal, for arranging any kind of a meeting, either on video conference or Zoom, etc., so that we could resolve any kind of raised doubts or difficulty so far discussed, lectures so far delivered, lectures. Thank you, thank you, thank you.